Good morning, everyone. For the people joining us by Zoom, is it possible for you to key in your name? And if it's not, if you can identify yourself.
Hello, it says my name is Jane, but actually this is my wife's computer and it's Brian Gorman.
What was the name, Kristen?
Brian Gorman.
Okay.
Brian Gorman, Gorman.
Thank you.
Doug Jordan, 475 Stones Lake Road.
Thank you. Anyone else, Kristen? Okay, thank you. This public meeting held under Section 34 of the Planning Act is declared open. The purpose of the public meeting is to consider the following applications. File number ZB 22064 being an application for zoning bylaw amendment submitted by Wayne Pichet and Glenn Beck to amend the township's comprehensive zoning bylaw as a condition of the severance of 3 waterfront residential lots. File number ZB 2206.5 being an application for zoning bylaw amendment submitted by Drew Tott to amend the township's comprehensive zoning bylaw to permit the construction of a single detached dwelling. And file number ZB 2206.6 being an application for zoning bylaw amendment submitted by JP2G Consultants on behalf of Newell Realty Limited to amend the township's comprehensive zoning bylaw as a condition of severance of 3 waterfront residential lots. Would the planner please confirm that the required notice was given for the subject applications in accordance with the requirements of the Planning Act?
Thank you, Mayor Hunt. Yes, I can confirm that the required notice for all applications was given in accordance with the Planning Act. Thank you.
All those present at the public meeting will have the opportunity to speak in favor or in opposition to the applications. Any and all comments and information submitted, whether orally or in writing, including identifying information, becomes part of the public record and could be made publicly available at any point, including on the township's website and other electronic forms of publication in accordance with the Planning Act requirement. Any person wishing to receive the notice of decision regarding the applications being considered must send an email request to the township office immediately following this meeting, and in all cases, must be received prior to the date of the decision of council on the matter. Anyone who previously sent an email concerning the application will receive a digital notice of decision without further action. Pursuant to the provisions of the Planning Act, the rights and limitations of appeal to the Ontario Land Tribunal with respect to the decision of council on the application are as follows. A person or public body may file an appeal with the Ontario Land Tribunal within 20 days of issuance of the notice of decision. The person or public body must submit the required form of appeal to the town, which shall include the required information and an explanation of the reasons for objecting to the decision, in addition to paying the required fees as set out in the by the Ontario Land Tribunal Act. If a person or public body does not make an oral submission at the public meeting or makes written submissions to the township in respect of the applications before the approval authority passes or refuses to pass the proposed zoning bylaw or amendments thereto, the person or public body is not entitled to appeal the decision of the council to the Ontario Land Tribunal. If a person or public body does not make oral submissions at a public meeting or make written submissions to the township in respect to the applications before the approval authority passes or refuses to pass the proposed zoning bylaw or amendments thereto, the person or public body may not be added as a party to the hearing of an appeal before the Ontario Land Tribunal, unless, in the opinion of the tribunal, there are reasonable grounds to do so. Would the planner please describe the purpose and effect of the proposed zoning bylaw amendment to file number ZB 2206.4, submitted by Wayne Pichet and Glenn Beck?
Yes, thank you, Mayor Hunt. I'd be pleased to. And it's a pleasure to be here this morning. I'll be joining the mayor and members of council and everyone in attendance here today. So this application is with respect to lands known municipally as 45 Eagle Lane, located in part lot 15, concession 9, geographic township of Madawaska. The purpose of the application is to rezone the rear portion of the new lots, of 3 new lots, having county application numbers B108, 109, and 11021. It's to rezone the rear portion of those new lots from rural to limited service residential, to recognize the fact that they're going to be accessed via a private road. So again, this is an application requires a condition of consent, the consistency and conformity with the requirements of the county official plan and provincial policy and legislation have already been dealt with through the consent application. So this is very simply a condition that's required to implement those new lots. And if the applicant is in attendance and wishes to speak to the matter, they can do so at this time at the pleasure of council. Thank you.
Oh, I'm sorry.
No, it's just straightforward. We amalgamated 2 pieces of property that we own, and they're zoned differently. And the zoning, according to the county, should be the same because it's now 1 piece of property, and that's what this application is for.
Thank you. Does anyone wish to speak in opposition to the amendment? Do you want to come up to the, and hit the button until it turns green there, please?
No, I'm here. Helga Clausen owns 45 Eagle Lane. That's my mother-in-law. And the only thing that she wanted to know is, through this application process, does it hurt her right of way to her property in any way, shape, or form?
Okay. Eric?
Sure, I'd be glad to answer that, and through you, Mayor Hunt. So any rights and privileges that you have on title aren't impacted by this. So if a property was severed and you had a right of way over a larger piece and it was severed into 2 lots, you retain the benefit of a right of way over that portion. So this shouldn't affect your rights rights of way in any way.
That was her concern. That's well, it's the law. It says it's a cloud issue. Well, I just want to know how close to our property. Do you know, Wayne, how close it comes to our trailer? Pardon? Do you know how close the lot comes to our trailer? It's like 20 feet off or 10 feet off.
One of the lots goes right up.
Yeah, right, it butts up to the property.
Right to the body of your property.
Yeah.
And your property's there, and line is.
Yeah, I know. Is it like from, our trailer, is it about 10 feet off the trailer or something like that?
Yeah, you're right close to the line.
Yeah, right. Okay.
But actually, where the proposed building would be
Back far.
yeah. Well, they have to build also back from, these are very close, and that's
Yeah.
nowadays you have to build
50 feet off the line?
100 feet you want it.
Oh, 100. Oh, okay.
So,
Yeah. So there's no impact to her right away.
Okay, thank you.
That was her question that she wanted answered officially, I guess.
Thank you.
Okay.
Does anyone wish to speak in favor of the amendment? Are there any questions from members of council? Are there any written comments that were received?
No, there were no written comments received.
Thank you. And that concludes this. Would the planner please describe the purpose and effect of the proposed zoning bylaw amendment related to file number ZB 2206.5 submitted by Drew Toth?
Yes, thank you, Mayor Hunt. And through you, so this application is with respect to lands described as Lot 8, Concession 9, Geographic Township of Bagot. And the purpose of this application is to rezone the subject lands from rural to a rural exception 48 holding zone. And the reason is that the property is currently vacant. It's part of a leasehold development called Calabogie Estates. Correct me if I'm wrong. I guess Calabogie Estates, great. I'm getting there. And so this is currently a vacant leasehold parcel within the development. And the idea is that this parcel will be developed for another dwelling. And because it doesn't technically meet the definition of a lot within the zoning bylaw, a rezoning is required in order to permit this to occur. Otherwise, it wouldn't be. The holding symbol is proposed in order to deal with the provision of water and sewage disposal services, and so we'll be requiring a hydrogeological report as a condition of removal of the holding symbol, and we've advised the applicant of that requirement. And so I think that's about it. We also have to deal with the fact that there's a separation distance from the extractive industrial reserve zone. And they've provided a plan justification report that demonstrates that there's likely to be limited impact on the ability to utilize that deposit. And the reduction will be from 150 meters to 76 meters in terms of a separation from the construction of a new dwelling. So I believe that's it. If I'm missing anything, I'd certainly appreciate it if the applicant would jump in. I think that pretty well summarizes it, though. And those will be my comments at this time. Thank you.
Thank you, Eric. Mr. Toth, would you like to speak to it?
Thank you, through you, Mayor. I don't have any specific comments. Eric summarized it pretty well, but I'd be able to answer any questions that council or any neighbors have. And I would want to hand it off to Daniel Romanko, who will be representing me as the planner, to talk about some of the specific planning details. Dan, if you can go ahead.
Thank you. Good morning, Mr. Mayor, members of council. I have a short presentation I'd like to share if I'm permitted to do so. Would that be possible? I don't have permissions at present. Thanks. Okay, trusting everybody can see my screen. So I'm a planner with Better Neighborhoods, and I'm here on behalf of the applicant, Mr. Toth. Just for a little bit of context here, you can see the property. The subject site is one of several leasehold lots in Calabogie Estates. There's some history regarding the ownership structure, but Calabogie Estates has established these lots through lease agreements, and essentially this parcel functions as a separately conveyable parcel. The applicant is also an owner of Calabogie Estates. You can see on the map here that Calabogie Estates owns everything highlighted in red. So that does include the extractive lands opposite Highway 511. These are just some photographs of the site, and this is the proposed site plan. Showing proposed well and tile bed locations. The site is suitable for a single detached cottage, which is proposed. These are some elevations. And the application is rather straightforward, which is just simply to permit a new dwelling where the current regulations only permit one per lot. So it's a bit of a technical ask in that regard. And you can see there's a history of leasehold properties already on Calabogie Estates established in the same manner through leasehold agreement. And the application supported by planning policy, there are no apparent land use incompatibility concerns both for the impacts on the natural heritage features or any other compatibility issues. So happy to take any questions.
Thank you. Does anyone wish to speak in opposition to the amendment? Does anyone wish to speak in favor of the amendment? Are there any questions? Oh,
I can't see the name though.
I can't see your name, but go ahead.
Phil. He's muted.
I think you may be muted.
He's not muted, but his sound.
What's that?
He's not muted, but his sound is not working.
I'm afraid your sound is not working.
Phil, if you'd like to call my phone, I could put my phone up to the speaker if you'd like.
He was speaking in favor.
He's waving it off. That's for a thumbs up, maybe. Oh, I think he's gonna call.
Okay, thank you.
Go ahead.
Okay. Sorry about that, Mr. Mayor. I'm Phil Benson. I'm the Secretary Treasurer of Calabogie Estates Limited, and I simply want to convey to you, to the committee, that Calabogie Estates Limited fully supports the motion that's on the floor right now, has no objections, and in fact it welcomes this development as a further development of Calabogie Estates Limited. Thank you. Once again, my apologies for the sound problem.
Thank you. Kristen, were you able to get that? Pardon me?
I believe you said Calabogie Estates.
Okay. So we're understanding, maybe you can give us a thumbs up if I'm correct here. We're understanding that you're in support. Thank you.
I have a message from Catherine.
Uh-huh.
Says she wants to speak in favor as well.
Catherine, you wish to speak?
Yeah, hi there. I'm Catherine Simpello. My father, we're in the point of transitioning land. My father is a lease part owner of Calabogie Estates as well, and it's being transferred to myself currently. And I just wanted to speak in support as well of Drew's application. Nothing further to say related to that unless you had any questions. Phil kind of summed it up. I just wanted to be here to support it as well.
She just wants to speak in support as well.
Okay.
Can we turn the volume up?
Okay, thank you. And so we got that you support the application as well. Correct.
Perfect.
Okay, anyone else wishing to speak? Lucy?
Yeah.
Councillor Perrier.
Just a question for CEL. I live on the same lake as everybody else does, which is CEL across from me. Is there an impact on anything else with the remaining property with this happening?
Eric, do you want to take that?
I'd be glad to. Thank you, Mayor Hunt. So again, this proposal is kind of another in a long list of properties that have been developed. I understand that there's still some vacant parcels that remain. We did receive a hydrogeological assessment recently that seems to indicate that there's quite a bit of room to run in terms of nitrate impact assessment in regards to the requirement to meet the 10 milligrams per liter maximum at the dilution at the property boundary. And well, maybe note just at this juncture, because it is related to this, we did receive comments from the MECP, Ministry of the Environment, Conservation and Parks. And they did indicate that it's possible they'll be requesting that septic approval will go through them in this case, depending on whether or not they're going to treat this as one property. I think, we'd like to maybe see a bit of flexibility on that from them, but we'll have to see. We're kind of just early stages in our correspondence with them, but they did respond to the statutory circulation through the Planning Act requirements, and so we'll see what happens, but the applicant and owner are apprised of the situation there. Thank you.
Okay, one more question, please. Is my understanding is that there was a move afoot to subdivide a whole bunch of CEL properties, but can't be done for some reason or another. So where are we at with the CEL Board of Directors? Are they in favor of this application, if I can ask?
You can just give me a moment for you, Mr. Mayor.
We can't hear once again, Lucy, but he was in support of the application. Would that answer your question? So, and he's thumbing up that he's in support of this.
I understand that, but I need to know that the whole executive from CEL are in support of it based on the ratepayers that are on the lake. That's all I need to know. Okay, thank you. Got it. Thanks.
Okay. Are there any questions from members of council? Any further questions? Seeing none. Are there any written comments that were received?
Thank you, Mayor Hunt, through you. So there was just the one that was received, I believe, from MECP. I don't believe there are any resident or public comments. Thank you.
Okay. And before I close it off, Eric, before I close it off, when you talked about the septic and all that, that'd be handled at the time of application for a building permit. Is that correct?
Thank you, Mayor Hunt, through you. It's so two stages. So we're going to need demonstration that the lands are suitable from a hydrogeological perspective, and then we'll lift the holding symbol for that. And generally speaking, we've got to get a hydrogeological study anytime we're dealing with a property or a parcel that's under 1 hectare. So that's the first step. Then the second step would be the septic permit, which at this stage, depending on which way kind of the wind blows with the MECP, whether it's going to be through the province or whether we're going to be able to deal with it at the township level. But yes, that'll come after the fact. So thank you.
Thank you. And so we'll move to the next one. Would the planner please describe the purpose and effect of the proposed zoning bylaw amendment related to file number ZB 2206.6 submitted by JP2G Consultants on behalf of Newell Realty Limited?
Yes, thank you, Mayor Hunt. Through you, I believe the applicant, Mr. Simon, is here on behalf of JP2G Consultants and Newell Realty. And so maybe before I give him the floor, the application is with respect to conditions of consent approval for county applications B74, 75, and 7607. They propose to create 3 waterfront residential lots. And the purpose of the reason that the rezoning is required is to reduce the EMR setback, extractive industrial reserve setback. And that setback is going to be reflected by a minimum front yard depth of 30 meters from the front lot line, as opposed to a straight line kind of as the crow flies measurement. It'll be implemented through a 30-meter setback along the front lot line. The water setback will remain, and then there will also be a holding symbol placed on the retained portion, And the reason for the holding symbol is to require a stage 2 archaeological assessment completed by a licensed archaeologist to satisfaction of the township. So that is the purpose of the application. And if the applicant at this time would like to offer any comments in addition, that would be fine. Thank you.
So would you like to speak to the application, the representative from JP?
Thank you very much, Chair. My name's Forbes Simon. I'm a senior planner with JP2G and represented Mr. Rump on this application. Eric has provided a very good summary of what's before you today, and I don't have anything further to add other than that we have done archaeological assessments on the severed lots. We've done environmental impact assessments, and we've done an aggregate impact assessment, all in support of the application that have been provided to Land Division Committee. And I'm available if council and committee have any questions.
Thank you. Does anyone wish to speak in opposition to the amendment?
Is that on Stones Lake?
Yes.
Stones Lake?
Yes.
Well, I'd like to talk.
Okay, come over to the.
My name's Cliff Struggle.
If you don't mind, just sit and hit the button there till it turns green. Thank you.
Okay.
Pull it towards you and
This here? Okay. Okay, I was an employee for the township there for 18 years, and I was retired when I was 60. But getting back to the 30 years from ago, the Flemings were going to put a golf course across the lake in Stones Lake, and Ralph Pedley was in on it. So anyways, what they were going to do is put a golf course in there. And then what they were going to do is put accesses from the golf course, and there was 125 homes going in there. So they were putting accesses from the homes into the lake. And like the lake is, you can drive a golf ball across it in any spot. So anyways, the Lands and Forests and the environment got a hold of this. So they took a whole thing about the lake. How deep is the water? How shallow is the water? How wide is it and everything? So it ended up there, the environment and the Lands and Forest had a meeting in the old town hall beside the church up there. And I was at that meeting for an hour and a half. And what they said, the environment said that they cannot put any more pressure on Stones Lake. That includes Pedley's golf course, no more access out to his lake or out on his property. And then what happened then, they took, and what they did, if you had a house on Stones Lake or a cottage, you could keep that. And if you wanted to build another house, you could build it in that spot. That's not the problem. But if there's no other dwellings on Stones Lake, you're not allowed to build. And that's what we're looking at today. 15 years ago, Rump went into the county or applied for a severance. So they put 4 severance on the lake, and the county did that. But I called the county because I know the people, and I got a hold of the person there that does the severances. And I said, you better take a look at your severances, because the environment and the county or the Lands and Forests said there's no more building on any, if there's no buildings, there's no buildings on it. There's not going to be buildings on it. And now Rump went to the county, took these severances off, and when I got done talking to the lady at the county, she discarded all the severances that was made. So that went down the drain, because you're not supposed to build, where there's no building, you can't build. So that's why I'm here today. And why these, and like I say, why these people are being allowed there to do something that you couldn't do 30 years ago, and now that's supposed to be all right. That's not good. That's our lake is so small and you know, it can't take any more people. Now they've got boats on there that's 500 horsepower. And we tried to get the environment there involved and tell them to get some of these boats off the lake, and it's just not happening as quick as we want. But anyways, that's my story, and I'm sticking to it. And like I say, the environment and the lands and forests, they canceled all of the building on Stones Lake unless it was something that was already there. Then you can go and revert to another one. And that's the way it is.
Thank you. Eric, at this point, do you want to comment on that and how it would be handled, or?
Yes, thank you, Mayor Hunt, and through you. So, yes, thank you for your comments. I think I'll allow the applicant to speak to this if they have any comments, but just from a process perspective, what I can say is that this is a condition of consent approval. Okay, so the actual severances themselves, they go through the county. There would have been a separate notice for that. There would have been notice posted on the property. That is the opportunity to object to the severances themselves. When the county looks at severances, they look at the official plan, they look at the lake itself, whether or not it's a highly sensitive lake. I don't believe this one is in the county official plan. The lots themselves are 1 hectare in size, so they are, and from a hydrogeological perspective, you know, the 1 hectare is considered to be the minimum lot area where it's considered that you're very likely to have suitable water and septic disposal. So there's not a requirement for a hydrogeological assessment. There was an environmental impact study that was completed with this in support of the severance applications. Again, what council is dealing with in this case is a condition of that larger approval. So we're just kind of one element of it. We're just implementing what the county is required through the severance process. So that's just from a process perspective. But if the applicant, I don't know if Forbes has anything to add to that, that'd be great. Thanks.
Thank you, Eric. Chair, through you. I appreciate the comments that were provided. It's important for the committee to realize that there are no policies within the Renfrew County official plan that speak to limits of growth and development on Stone Lake. I'm not questioning that there have been past discussions, but the fact that there are no policies that put that restriction on Stone Lake makes it challenging. And I think Eric is quite right that the matter before you today is the zoning, not the creation of the lot. The lot creation is already being through its planning approval process, and we're now satisfying conditions. And so I would respectfully request that council focus on the amendment before you and its compliance with the official plan.
Okay, does anyone else wish to speak? Okay, go ahead, please.
That me? I guess so.
Yeah.
Okay, Gino Sobe. I own 2 lots on the Stones Lake. Yeah, I'm concerned about the environment assessment for sure, because they were saying the older people on the lake have been saying that the lake will die within 5 years. So I am not in approval of building more lots on Stones Lake, but that might not be what you guys are at that process. I'm not sure. I just want to voice my opinion that I'm not in approval.
Thank you.
I have
Go ahead.
Sorry, Mayor Hunt. Doug Jordan, 475 Stones Lake Road. A couple of questions. One, it seems like there are two items being discussed. One is the 3 already severed lots, and the other is the additional portion. I'm not sure why they are lumped together in one quote unquote motion. Am I correct in saying we're discussing two different things this morning?
Eric?
Yeah, thank you, Mayor Hunt, through you. So you're partially correct. So the county, in making its decision on the severance applications, is required to be consistent with and to conform to applicable policy and legislation. And that includes the possibility that the retained lands could be developed in some way, even if it was with one single detached dwelling. And the provincial policy statement deals with archaeological resources, and there's the potential, due to the property's proximity to water, for the retained lot to have some sort of significant archaeological resources. That's not to say that they're there, but it has what's called archaeological potential. That potential has to be cleared by the Ministry of Tourism and Culture and Sport through the preparation of archaeological assessments, specifically a phase 2 archaeological assessment. And until that's done, we have the county has to include in its decision the requirement for the lands to be placed into a holding zone in order to make sure that those policies are dealt with. And I hope that explains it. Thank you.
If they're not put in a holding zone, what are they in?
Thank you, and through you, Mayor Hunt. So the current, I believe it would just be a straight RU, rural, and so there'd be nothing specifically prohibiting the construction of a dwelling or the development of the property for the uses permitted in the RU zone. So the holding symbol prevents the issuance of any building permits until the conditions of the holding symbol are met, and that being the clearance of archaeological potential from the property. I hope that answers the question. Thanks.
Further?
We're getting there. I'd like to continue. Sorry. I noted that the developer's representative, Mr. Simon, I believe, had asked council to focus merely on the following the planning, but it seems like the residents of Stones Lake were not aware that these 3 lots had already gone through the earlier requirements, the environmental study, et cetera, et cetera. And Mr. Strudwick mentioned that, and others. I wonder if council might have this one final opportunity, if you will, to allow us to revisit that, because once it seems if council were to approve this amendment, that's it, that's all that's done. Yet Mr. Strudwick and others have mentioned that we don't believe the county ever approached us, posted it, or called a meeting to advise us that the other 2 or 3 conditions had been met, and we would like an opportunity to discuss those. And so while it seems like it should be rubber stamp, and that's, I believe, what, if I could put words into Mr. Forbes' mouth, that's what he's asking for, I would respectfully advise or ask council not to rubber stamp this.
Thank you. A question, maybe Eric, when the holding symbol is put on, then when someone applies for a building permit, they look at that holding symbol. At that time, would there be a review to see if there was any conditions on it being a sensitive lake?
Thank you, Mayor Hunt, through you. No, so at that time, it would only be the conditions to removal of the holding symbol that are reviewed, and those are specified in the bylaw. So the exact nature of the holding and what's required to remove the H are specified, and that's only what's looked at. But maybe if I could just, so the you gotta be careful here. There is a process to approve the severances, and if it's being suggested that somehow notice requirements weren't met under the Planning Act for the severance application, that's a completely different matter entirely, and I'd encourage residents to speak to the county about that. That is certainly, would be an issue, but unless the applications are appealed, there's no, that's the recourse. So in the province of Ontario, when you're dealing with Planning Act applications, the recourse is to appeal the decision of the approval authority. And if that wasn't done, then that was the opportunity, and it's deemed that the applications were not contested. And if I might just add further, my understanding with the county delegated approval authority is that there's a very low threshold for when applications then go to Land Division Committee. The vast majority are approved at the staff level, but if any comments are received whatsoever, it does go to Land Division Committee. So again, the stage and the process to deal with the lot creation specifically and the requirements for that process, it was through was through the severance process with the county. That's not, the township doesn't have the ability to determine whether or not a severance is appropriate. We are not the approval authority in that regard. Thank you.
No, but my understanding is you do have an opportunity right now to stop the process by the very simple aspect of not approving this amendment. And while it's sort of a technicality, on the other hand, it is one opportunity to make sure that things are being done right. I'm not even saying they're being done right or wrong. I'm just saying we have an opportunity. I'd like to also mention that within the next 60 days or 30 days, and I don't have the number at hand, virtually every single member of this county will be replaced. There will not be a single member. At one time, it was thought that there might be one member of council might have another position on the council, but right now it appears that every single member of this council will not be in a position to affect or effect this decision in approximately 30-45 days. I don't have the date at my hand. I ask only that we allow the new group to have a look at this. It's only asking for 45 days, but both councillors have indicated they will not be running it. They are not running. The mayor has indicated he's not running. The two other councillors from other wards will not be running. And I'm just asking that this council maybe think of the future by not doing this. And I know there's technicalities. I understand that you can do. I understand lame duck and what it means, and this is not appropriate for lame duck. I'm just asking morally and ethically if this council doesn't want to think about that.
Thank you. I believe, as was mentioned by the consultant working for the applicant, is that the condition of it being a sensitive lake is not within our decision. We can't make a decision on that. And I believe if we did, it could be appealed to the Ontario Land Tribunal because that's outside of our jurisdiction. Would I be correct in assuming that, Eric?
Yes, thank you, Mayor Hunt, through you. Yeah, that's correct. It's not, we can't just deem a lake to be sensitive or have environmental concerns beyond what's in the official plan. We are, again, it's not the township. It's not within our purview to do that. If it's not already in there, there's an official plan review process, and including a lake as a sensitive lake could be part of that process, but this is not the process to do that. So this lake, understanding that there is perhaps some anecdotal suggestions about the quality of the lake. It's not identified as a highly sensitive lake in the county official plan, and again the applicant has demonstrated through the submission of an environmental impact statement that's been determined to be appropriate through the approval authority for the severances, that this development will not significantly impact any features, any ecological features of interest. I'll just note again, these are large lots. These are 2.5 acres a piece. We're not talking about half-acre lots. They are quite large. It's probably the kind of development that you want on a lot like this. So, applicants would certainly, be within their rights to come forward with 1-acre lots and provide a hydrogeological assessment and whatnot. I think that these are generously sized lots. I think if you're going to have any development on the lake, this is the kind of development that you would want. And again, just with respect to the kind of the suggestion that that the township use this opportunity to kind of effectively halt an approval granted by another authority. I think staff would not recommend that happen. I think there is a reason that this application is before council, and I think it needs to deal with the subject matter of that application and not go beyond that. And that would be staff's recommendation on the matter. Thank you.
Eric, so if the people in opposition to this approval, if they want to get further information about the sensitive lake matter, I think they're best to reach out to the manager of planning at the county level. Would that be correct?
Yeah, thank you, Mayor Hunt, through you. That's correct.
So I guess our advice to you, to the people in opposition, because of it being as sensitive, is to reach out to the manager of planning, Bruce, at the county level, and try and get an understanding on why they went ahead with those. I don't know if there's anything you can do to turn it around, but they're the ones that would have the answers on the sensitive lake side of it, and not this council.
Again, without monopolizing the meeting, if I could say, this is quote unquote our last kick at the can, and this is your last or one of your very last meetings as a group, and all we're asking is that we be allowed to talk to the county about these things. If you approve this, so many hands are tied so quickly, and we're just asking that you morally and ethically say, okay, we won't tie your hands. We'll let the county deal with this. Right now, staff is saying, let the county deal with this. And we're saying at a local level, both Chuck and Lucy in our wards and the councillors in the other wards and the mayor himself have one final chance to serve the members of Greater Madawaska before County of Renfrew makes decisions. That's what we're asking.
Okay, and understand that this will not be approved today. This will go back to staff, and staff will be bringing it to a further council meeting. So what I would suggest is that you get on the phone right away and contact the manager of planning so that you do have some time. When would the earliest this would be brought to council would be, or it would be this Monday? Is there a
point taken?
Okay. Is there a time limit when you have to bring it to this council?
There's not. We could bring it to council at the pleasure of council, but again, I think unless there are issues that we're not, were not considered by the county. I would caution against intentionally delaying a process. I think that if that ever got to the Ontario Land Tribunal, that would be a very costly and expensive appeal, and it would not be favorable for the township. So I would just caution against that. But certainly we can bring the matter before council whenever it would like to see it.
If I may, this will come to the meeting on Monday. If council so chooses, they can vote to delay this to the October meeting or a later meeting, but this this report will come to the council meeting on Monday.
Okay, so hearing that it will be coming to council and council will be making a decision at that time. And as the CAO said, it could be to delay, but we've been cautioned by staff of the repercussions that could cause us. But that does leave 4 days for you to have
Two
a
of which are the
conversation.
weekend.
Pardon me?
Several of which of those days are the weekend, and they're not available
Today
to
is
us
Tuesday,
to
isn't it?
discuss things.
Yeah, it's Tuesday.
Okay, well, today is Tuesday, so Tuesday, Wednesday, Thursday, Friday. That gives those 4 days to have a conversation with the manager of planning and try to understand why they made the decision. So I think we're going to leave it at that. Is there any further comments?
Mr. Mayor,
Yes.
it's Brian Gorman speaking. I'd like to make a comment. I have
Okay.
a property also on Stones Lake Road. Notice of decision. I'd like to get back to the zoning, and this is directed towards Eric. The notice of the decision, section 3, says that the zoning bylaw amendment be finalized. And it's noted that each decision, and there's 3 lots, so there's 3 decisions, that the severed lot, and it says severed lot, so there's one for each decision, be rezoned from RU to RU exception, which is fine. Why are we rezoning the entire property, the length of Stones Lake Road, when the decision only addresses 3 lots?
Eric, do you want to take that?
Yes, thank you, Mayor Hutton, through you. So again, just to go back to the holding symbol, that's the holding symbol is being applied to the balance of the property.
Yes, I understand. I understand the holding symbol is there, but doesn't the rezoning of the entire property do possibly 2 things? Tie the hands of the landowner so that he has to do what the county is requesting, which would be larger lots, or does it leave him open to do other things without coming to council and using that exception zoning to, say, circumvent public meetings, that type of thing? Why I'm saying that is that the 3 lots, and it talks about setback from mineral reserves, as Mr. Strudwick said, but the 3 lots, there's no reserve on any map that I have seen within 30 meters of that 3 properties that are being severed. However, further up the road, there is a lot of places where maps indicate that's an EMR reserve. Now, if he's given permission now to do anything within a 30-meter setback, is that really an honest way to do it when we're only looking at 3 lots and he's getting a 30-meter setback possibility for properties further up the road?
Eric?
Thank you, Mayor Hutton, through you. So I'll maybe just clarify, the 30-meter setback only pertains to the severed lots. That doesn't apply to the balance of the property.
Well, then why does the entire zoning apply to the balance of the property and not just the severed lots? Understanding the holding conditions, but why is that land being put into a holding condition when it could just be left the way it is?
Thank you, and through you, Mayor Hutton. If I may just finish my comments, I'd appreciate it. Thank you. The holding symbol applies to the entirety of the retained portion, and it actually reduces the development potential of the property until such time as they come forward with a ministry clearance letter. So left as is, they could actually do something with it. With the holding provision on it, they can't. So I think maybe there might be a wrong impression here that rezoning the retained gives more permission, development permission. In fact, it limits it.
Okay, thank you.
Okay, are there any further comments in opposition? Does anyone wish to speak in favor of the amendment? Are there any questions at this time from members of council? Are there any written comments that were received?
No additional written comments were received.
Thank you. This therefore completes the public meeting process. Council will give careful consideration to the applications for zoning bylaw amendment. And without further comments or questions, I declare the public meeting closed at this time. Thank you.